Hey guys, welcome back to the channel. Today, we've got two sovereign citizens in court to break down, and trust me, the last one is absolutely unbelievable. We're talking about a man who genuinely thinks he's a king in custody. Yes, that's what he calls himself, and even after taking a plea deal. He still believes his imaginary diplomatic immunity is going to protect him from spending decades in an American prison. Spoiler, it's not. Not even a little. But watching him explain it is pure entertainment. So stick around for that meltdown. Before we get to him though, we're starting off with a classic, a softie. Karen, who managed to get herself pulled over in a way that almost feels like a parody of bad decision-making. She was literally smoking reefer while driving, with her mother-in-law sitting next to her and her 3 kids in the back seat. Just incredible life choices happening all at once. If there was an award for reckless multitasking, she'd be giving an acceptance speech and a quick behind-the-scenes note before we dive into the details. A lot of you have told me how much you hate hearing all the ums, ahs, and random filler noises people use when their brain freezes mid-sentence. Well, buckle up, because this video was packed with them. I counted over 200 in less than 20 minutes. 200. I didn't even know humans could produce that many verbal glitches in such a short time span, so yeah. I spent more than 2 hours chopping every single one out, so your ears wouldn't have to suffer, and so the pacing actually makes sense. It was like audio whack-a-mole, but we made it through. Alright, enough setup. Let's jump into the first case, because Karen did not disappoint.
All right, so we are convening, as mentioned, for a hearing on motion in case 2025 M42. The defendant is Ms. Jasenia Amber Raby. Ms. Raby appears today via WebEx. Ms. Raby, ma'am, it's Judge Murphy here. Can you hear me okay?
Yes, Your Honor.
Terrific. All right, and thank you very much for your appearance today. I hope you didn't get as much rain as we got overnight, so you probably were going to be in worse shape trying to navigate the roads today. But
fully, completely washed out, so.
Oh, well, I'm sorry to hear that. Okay, so let me just give you an overview of kind of the way this works, because since you're representing yourself, I just want to, let's just start with that question. Are you comfortable continuing to represent yourself or for purposes of this hearing as well?
Yes.
I'm sorry, was that a yes?
Yes, sir.
All right, thank you, ma'am. All right, so the procedural history here is that on August 5th, 2025, when you appeared personally, you submitted to the court a lawful challenge to jurisdiction, standing, and authority, as well as an additional, that's a 2-page document, and then an additional 3-page document that was entitled Affidavit of Standing and Rebuttal of Jurisdiction. So generally speaking, the party who makes a motion goes first and argues his or her assertions. You don't have to, if you want to just stand on the pleading, that's what we call it. If you want to just say everything in writing is all I have to say, you can do that. But I want to give you the opportunity first to be able to run through the various points that you have. Then the people, and Mr. Bama is here on behalf of the people of the state of Colorado, the people will offer their position as to your arguments, and then ultimately I'll have to make findings and then either grant or deny your motion. So with that said, did you want to go ahead and begin with anything you want to state?
Everything I have to say is in writing.
What she's really saying is that all of her so-called legal expertise looks like it was scribbled in drool on a delicious, slightly crunchy sheet of lead-infused construction paper. You know the type. The kind only a sovereign citizen could proudly hold up in court as if it were the Constitution itself. And don't worry, because the judge is just seconds away from strolling in, sitting down, and swatting away every single one of her motions like they're fruit flies hovering over a gas station sandwich. No hesitation, no internal debate, no let me think about it. Just instant, effortless denial across the board. But before we get to the judicial demolition derby, we need to rewind a bit and set the stage properly. The officer's testimony is where the entire situation truly comes into focus. Because this wasn't one of those complicated legal puzzles sovereign citizens love to pretend they're trapped in. No, this was basic, straightforward, here's what happened and why we're here material. Yet somehow she managed to twist the simplest facts into a conspiracy theory, legal thriller, and personal victim narrative all at once. So we're going to walk back through what the officer observed, what he had to deal with, and how the whole thing escalated into the circus we're about to watch unfold. This foundation is important because once you hear the officer's side, every one of her bizarre motions, from the nonsense about jurisdiction to the rambling about commercial codes, to whatever cosmic law she believes she operates under, will make even less sense than they already do.
Okay. All right, ma'am. Thank you very much. Mr. Bamas, sir, do the people have any argument to make with respect to this motion?
Yes, Your Honor, we have argument that we do have a witness. Caitlin Bills is on WebEx.
Okay. All right.
I intend to call her briefly.
All right. Very good. Do you want me to swear her in
Yes,
now?
please.
Okay. Deputy Bills, ma'am, good afternoon. Are you able to unmute yourself and switch on your camera?
Yes, sir. Sorry, I'm trying to get my camera on.
No problem. I know it's a little cumbersome, so thank you very much for your appearance and your getting the WebEx machine thing to work.
Yeah.
Okay to myself.
Yeah, you can mute yourself. If you want to say something, just raise your hand and get my attention, and I'll and you'll have an opportunity, Ms. Raby, to cross-examine Deputy Bills. So what'll happen is I'm assuming Mr. Bame is going to walk through some direct testimony or solicit some of her direct testimony, and then you'll have a chance to cross-examine her. You can ask her questions about what she said during the course of her testimony. You don't have to, but that's your right. All right. Good afternoon, Deputy Bills. Nice to see you. Could you please swear or affirm under penalties of perjury that the information, that any testimony you're going to give today is the truth, the whole truth, and nothing but the truth?
I swear.
Okay, very good. Thank you, ma'am. All right, Mr. Bamas, sir.
Thanks. Is it okay if I stay seated?
Yeah,
Okay.
stay seated. There's no
Okay.
formality required.
All right, state your name, please.
Caitlin Bills.
And were you employed as a 42925?
Yes, as a corporal with the San Miguel Sheriff's Office.
And did you receive information about a traffic complaint when you were on shift?
Yes, sir.
And do you recall how you received that information?
Via San Miguel County Dispatch over the radio.
And what information did you receive?
Information about a black Jeep Wrangler or Rubicon Jeep that had a pink crown in the back window with temporary plates that was going a slow amount of speed on Highway 145, 1 mile marker 19, and that was failing to maintain a single lane as the vehicle was driving towards Norwood.
Mr. Adams was concerned. What was he concerned about when he made the call?
The driving behavior of the Jeep and the fact that it was going slow and failing to maintain lane, while also when he had passed that vehicle, he had smelled marijuana and seen the driver smoking what looked like a marijuana cigarette or something along those lines to him.
Mr. Adams had to actually pass this vehicle in San Miguel County to get around safely.
Yes, and he also had to hit his brakes because the vehicle was going so slow, so it impeded his traffic when he was trying to drive and his safety as well.
Okay. Eventually, did you come in contact with the Wrangler?
I did, in the town of Norwood on Grand Avenue.
Why did you initiate a traffic stop?
I had seen the Jeep Wrangler stopped at a stop sign on Grand Avenue and North Pine, and it had sat there for an extended period of time. Then quickly turned into the marijuana shop, Alpine Wellness, in Norwood. Within less than a minute, it had pulled in there. He had given good descriptors of exactly what he had seen and observed and smelled. I initiated the traffic stop and contacted the driver, Jacina Ragu.
And what was your tone when you first initiated the stop?
Conversational. Well, when I first started it, I had yelled stop at her because she almost backed up into my car. But after that, it was conversational.
So after you had to practically raise your voice to the decibel levels of a rock concert just to prevent her from plowing into the car in front of her, and probably several more on either side, you finally got a fleeting moment to try to communicate with her like she was a normal human being and not some walking disaster magnet. And even then, it wasn't exactly a pleasant conversation. Every word had to be carefully measured, every pause timed perfectly. Because one wrong syllable and she might have veered off into another ill-advised stunt. Or worse, dragged someone else along for the ride. For a moment, it was like trying to negotiate with a tornado, hoping that a tiny bit of calm and reason could somehow survive the chaos swirling around her. The sheer absurdity of the situation only amplified the tension, making it painfully clear that this wasn't just a traffic stop, it was a full-blown exercise in crisis management. Patience and damage control rolled into one surreal encounter.
Was there anybody else in the car with the defendant at the time of the stop?
Yes. Her mother-in-law was the passenger, and then she had 3 young children in the back seat.
And eventually you do have a conversation with the defendant, and I'll say that that's beyond the scope of what we're talking about today, but just to kind of paint the complete picture, you have a conversation with the defendant, and then is she ultimately charged with driving under the influence of drugs?
Yes, sir.
Okay. And did she consent to any tests?
Yes, she consented to voluntary roadside maneuvers.
And how about any chemical testing?
Yes, she consented to a chemical test of her blood, and when she consented, she said that there would be THC in her blood.
Okay, and what else did she tell you anything else when you were conducting your investigation?
She had told me that she had smoked marijuana. It had been outside of her car, and this was after she initially had lied to me about that she hadn't smoked at all, and she changed her story. But she had pulled over and she had smoked outside the car, and it had only been 1 joint, even though the car smelled like burnt marijuana on the inside, and there was burnt marijuana cigarettes that were visible in the ashtray.
Okay. For the purposes of this hearing, those are all the questions that I have.
So, Ms. Raby, this is now your opportunity to cross-examine Deputy Bills about anything that she offered as testimony. If you'd like to do that, you're welcome to go ahead. You don't have to do it, but it's your right.
I don't have any questions to cross-examine.
That's probably in your best interest. Honestly, if we're talking about what would truly be in your best interest, it starts with not getting behind the wheel while completely baked, especially with your 3 young kids strapped into the back seat, completely at your mercy, while you make choices that could have catastrophic consequences in a split second. But let's not stop there, because right after putting down the joint and stepping away from the driver's seat, the next thing on that list should absolutely be hiring a real lawyer. You know, someone trained in the law, familiar with courtroom procedures, and capable of actually protecting your rights instead of fumbling through. Self-representation like it's some sort of DIY YouTube tutorial on how not to get arrested. 101. The combination of bad judgment behind the wheel and attempting to navigate the legal system solo isn't just reckless. It's a perfect storm for disaster. And anyone watching this play out can see exactly how quickly things could spiral completely out of control.
Ms. Bills, thank you very much for your time and appearance today. I appreciate your working with the WebEx machine as well. Okay.
Yeah, sorry about that. Have a good day.
No worries. Okay. Do the people have further argument or evidence or presentation?
No further evidence, ready to make argument. I don't know if I think just for protocol,
Ms.
I'm gonna
Raby?
open up to Miss Raby first.
Yeah. So did you want to, Ms. Raby, this is the time when you can make effectively what would be a closing argument, a summary of what your assertions are in support of your motion. Again, you don't have to say a word, but if you wanted to offer a global overview of what you're advancing in your motion, you're welcome to do that. Do you wish to do anything like that?
No, everything that I have to say is going to be written to you in certified mail.
Mr. Bamasur, do the people wish to make
Yeah, thanks. In order to make a traffic stop, the police must have reasonable suspicion that a person has committed a traffic violation or other offense. Suspicion is reasonable when there is an articulable and specific basis in fact to support it. And the police must have specific and articulable facts or rational inferences from those facts, which would support a reasonable suspicion of criminal activity and thereby justify the intrusion into the defendant's personal activity. The reasonable suspicion here was articulated by Deputy Bills, and it started with a citizen informant or ready report, if you will. And the ready report is something that has been dealt with in Colorado courts before, and they can serve to justify or create that reasonable suspicion. And I think in this specific case, that reliability is all the more established based on the fact that this was a trained law enforcement officer, albeit he was working for the jail at that time and not necessarily a patrol officer, but still law enforcement and still understands what's required when you're calling in a ready report. Also, peeling in front of the marijuana store and almost backing into Deputy Bills during the stop, again, that just leads to the reasonable suspicion for this stop. And the site that I'll have there is kind of the cumulative reasonable suspicion is People v. Garcia, 789 P2D 190192. Colorado, 1990.
So now that the facts have been meticulously laid out, with every piece of evidence pointing toward probable cause that a crime was committed, and it's become increasingly clear that the defendant herself was almost certainly the one responsible, we can finally move on to the next stage of the proceedings. This is the part of the courtroom drama where the judge takes center stage, methodically working through the mountain of motions the defendant has filed. Motions that, in hindsight, range from frivolous to downright absurd. One by one, each request is carefully examined, dismantled, and ultimately denied, leaving no room for excuses or creative reinterpretations of the law. The judge's approach is deliberate, almost surgical, highlighting just how out of touch these filings were with both reality and legal precedent. By the end of this process, it's evident to everyone present, from the attorneys to the spectators, that the Otzi Ruby Kiss. Only Ruby Kiss has the luxurious texture that glides on. Live size, live / long last. Long-lasting color, last in. By the end of this process, it's evident to a clause, it's divis quieti, with Keppel 8, Wes, my westus lies. Illis. Defendants' attempts to manipulate or delay the proceedings have failed spectacularly, setting the stage for the courtroom to continue with the matter firmly under control.
All right, Ms. Raby, I just want to make sure that I, as fully as I can, address some of the points that you articulate in your written motion. And then I'll also layer in the discussion that the people have highlighted here about the reasonable suspicion or lack thereof, etc. But I think I did, as part of the record during your last appearance, inform you that in any criminal case, including this one, that the court has authority over that case as a result of Article 6 of the Colorado Constitution, Sections 1 and 16, as well as a basis being Colorado Revised Statutes, Section 13-6-106. Further, that Article 6 of the Constitution, the Colorado Constitution, more specifically Section 17, does grant the court subject matter jurisdiction, meaning that this type of act, this type of case is appropriate to be heard in the county court. In addition, that point is emphasized further by Colorado Revised Statutes 18-1-201 and Colorado Revised Statutes 13-6-106. I also noted for the record during your prior appearance, and will do so again today, that personal jurisdiction was in effect achieved or perfected as a result, first, of the issuance of the underlying summons and complaint, which was served to you by, I guess, Deputy Bills, yes, back on April 29th, 2025, during that traffic stop that was just discussed as part of her testimony. And then your personal appearance here on August 5th, 2025, also reaffirmed that personal jurisdiction, meaning I have authority over you as a person. I have authority over this case given the subject matter of the case. And with that, I also want to draw your attention to my oath of office then, that was administered on the 8th of June 2020 by District Court Judge D. Corey Jackson, as well as the State of Colorado Department of State having issued a certificate certifying, more specifically the Secretary of State certified that on November 8th, 2022, that I, Sean Murphy, was duly retained as a county judge in the 2022 general election, that being the county judge for San Miguel County, Colorado. So let me turn then, with that background highlighted, to some of the assertions you make. Your document that's titled Lawful Challenge to Jurisdiction, Standing, and Authority, in which you say this is a lawful and peaceful demand for proof of proper jurisdictional standing. That I have just provided to you in terms of the county court's jurisdiction over this matter, more specifically subject matter, as well as you as a person, as well as my oath and retention certification. So therefore, that is proof of jurisdictional standard. You further provide, or you further request that we produce reasonable articulable suspicion, so also known as reasonable suspicion. So the people have addressed that in their argument, and the court, well, this is where we get into the ready report here. And as Mr. Bema has highlighted, that in this matter, in this particular case, there was this report from an off-duty San Miguel County deputy who did observe certain traffic violations, including the weaving, I suppose, as well as he had both seen and smelled the presence of marijuana emitted from the vehicle and seen you smoking what appeared to be a cigarette of some type. And so that information received from Corporal Nick Adams is something that what we call the totality of the circumstances has to be considered, as well as the circumstances surrounding what Deputy Bills observed directly that she just testified to. And so on that basis, I'm going to, at this point, for purposes of this motion, make a finding that reasonable suspicion did exist. The sort of test here is that generally speaking, Colorado law provides that a ready report, that being that report every drunk driver immediately, it can suffice even on its own to establish reasonable suspicion for a traffic stop, but that the sufficiency of that depends on the totality of the circumstances, including the reliability of the information provided, which I'll make a finding that it on its face looks reliable, that a report was received from a reliable source, that being Corporal Nick Adams. So reliability of the information test seems to be or is met, and therefore the court also is required to consider any corroboration by law enforcement. And so Deputy Bills's statement of her observations immediately prior to the traffic stop, while not direct corroboration of what Deputy Nick Adams or Corporal Nick Adams observed and reported, does support does support and is a factor to be considered, and therefore the court having considered that, the court does find that reasonable suspicion did exist for this traffic stop. So with that, let me turn next to, I guess this is on page 1 of that previously mentioned document. You've asked as item 2, the name and identity of a verified claimant. Well, the verified claimant is the state of Colorado through law enforcement agency, San Miguel County Sheriff's Office. So there is a verified claimant that is advancing this case in this court. Item 3, you asked for a sworn affidavit of injury. Well, there's no actual injury in fact, and so that's outside the scope of this analysis. And so therefore, an affidavit of injury is not something that's appropriate or required in this circumstance. Item 4, you asked for proof of lawful delegation of authority, and that's why I would refer you back to my oath and my retention that I mentioned earlier. And then item 5, you do ask for proof of lawful jurisdiction. And again, I've cited the Colorado Constitution and Colorado Revised Statutes sections that provide the lawful jurisdiction information that you were seeking there. So let me turn next to your second submission. That's the 3-page document that was entitled Affidavit of Standing and Rebuttal of Jurisdiction, in which your first item on page 1 says presumption of statutory participation rebutted, and you claim that you need a written bilateral agreement bearing your signature in order to require your participation. And as Mr. Bema noted, that in his answer or his response that he filed on August 29th, 2025, it's noted under the jurisdiction explanation that pursuant to Colorado Revised Statutes 42-2-101, subsection 1, except as otherwise provided, no person shall drive any motor vehicle upon a highway in this state unless that person has been issued a valid driver's license. And, the traffic code, let's go to point 2. Colorado Revised Statutes 42-4-103, stating that the traffic code, which you've been alleged to have violated, applies to all streets, roads, and highways throughout the state. So that is a supporting factor, very much so, in terms of the lawful jurisdiction here and the presumption that you'll be required to participate in this kind of a proceeding. Item 2 on that second document states there's a lack of verified claim and jurisdiction. For the previously mentioned reasons, there is not a lack of a verified claimant and there's not a lack of jurisdiction. You, in item 3, state that there's a rejection of public charge or democratic involvement. Public charge being a public benefit, I guess you are making, in fact, use of public roadways. And so I don't think that you can simply reject through your written submission the fact that you're not, because you actually did. You were observed on Highway 145 at 2 locations by an off-duty officer as well as a non-duty officer. So you were making use of the roadways, and therefore that's not a valid complaint or a valid argument against the search that was conducted. Item 4 on page 2 of your second document is titled Jurisdiction and Consent Challenge, and you cite Terry v. Ohio, as well as Louisiana versus Defenders of Wildlife, and claim that you do not consent to jurisdiction, but for the reasons previously mentioned on the record here, you have consented by driving a motor vehicle on a Colorado highway. Item 5 in your second document indicates that notes that there's a contract and due process requirement, and you make reference to the Uniform Commercial Code, sections 1-103 and 1-308. So the Uniform Commercial Code has no bearing on a criminal law proceeding in the state of Colorado. So notwithstanding any registration you may have performed by filing any kind of a Uniform Commercial Code document with the Secretary of State, that is not relevant here. And so it's not an argument in favor, in fact, of your motion. Then you, as item 6, note an affirmation of self-determination and international law, and you state that you lawfully reject all presumptions of your status as a taxpayer, donor, ward of the state, and you do not accept or participate in any public charge or governmental benefit which would diminish your right to self-identification. I think it meant self-determination. So for the reasons previously stated, you have availed yourself of a governmental benefit, that being a public roadway. And so this argument is not persuasive to the court. So with that said, I am obligated for those for the reasons previously stated, the findings previously stated, to deny your motion in this matter. And therefore, what we next need to do is just set a return date for the next hearing in this case.
SO. As I've already pointed out, every single one of her motions, and I do mean every last one, including the bizarrely shoehorned requests that somehow dragged in the Uniform Commercial Code, as if that had any relevance to what's happening here, has been thoroughly examined and summarily denied by the court. Each argument she tried to make, no matter how convoluted or far-fetched, was systematically shut down, leaving her with zero legal ground to stand on. The judge didn't just wave them off casually. There was a clear, deliberate dismantling of each motion, demonstrating how out of touch they were with the law and the facts of the case. Now, with her attempts to manipulate or delay proceedings completely neutralized, the courtroom can finally move forward. The only remaining administrative step is to officially set the date for her next hearing, giving everyone involved, the prosecution, her own defense, and the court itself a clear timeline to prepare for what comes next in this unfolding saga.
I would propose, how much time would the people like? Is a month sufficient time, or
Less than that. I mean, we've made an offer, and I discussed it with her at length before, and the conversation was the offer is going to expire if you go through with this hearing.
Mhm.
I'm willing to. I mean, I don't usually have that hard of a line on that, so I'm willing to talk with her still, but otherwise we're ready to go. I mean,
Okay, what if we came back in 2 weeks, October 28th at either 9:45 a.m. or 2 p.m. And then at that point, if that date and time, one of those times on that date would work for you, Ms. Raby, we would just be holding another, what they call pretrial conference. And then there would be possible discussion of whether or not you were interested in taking that offer. And if you don't have to take the offer, it is your right, of course, to enter a plea of not guilty and to request a trial, either to a judge or to a jury. And you can weigh those options between now and then as well as weigh the offer that you've received, and just let us know kind of where you stand at that point. Would that date and one of those times work for you, ma'am? October 28th, either at 9:45.
Sorry, I think
she froze.
She was
Yeah.
still muted
Sorry about
there.
that.
Yeah.
Oh, I'm sorry, Ms. Raby. If you wanted to say something, can you unmute yourself?
Sorry, I didn't realize I still had myself muted.
No problem.
Yeah, October 28th should be totally fine. Can we do the 2:45?
2
Since I have
o'clock.
to get my kid to